So, well, I promise
And
to hold you. Yeah.
and you know, even they could have many of such judges in supply in the system if there is courage and intent to clean the judicial.
Okay.
I mean, before the recent election, I mean, there was a outcry against the judiciary, no confidence.
Yeah.
Afrobarometer, uh, Mo Ibrahim,
Hmm.
this thing assessment, and even it internally, people had no confidence. I mean, social media, you just find views,
Yeah.
particularly the Supreme Court, they call them Unanimous FC.
Yes.
Oh, yes, blatantly.
Hmm.
And it was so. The cry against the judiciary was so high.
Yeah.
Now, there is a new government. What do you do if you intend to, if your cry against it at that time was principled? This is
Yeah.
the time you should flush out the bad elements.
Okay.
You know, you only take time that you don't do it politically. But those who can be shown by empirical evidence to have been uh, political poodles, you get them out,
Okay.
and then uh, you can amend the constitution, or even without it, just make sure that those coming to replace them are competent and independent.
Okay.
That should be the basis.
So, should the
If you go
Supreme
and
Court have
bring,
a cap?
is it?
Do you think the Supreme Court should have a cap?
Um, well, oh yes, why not?
Okay.
Because the propensity of African political magnates is to juggle the system to fit their idiosyncrasies each time they find themselves in the saddle of power. And so it's important to prevent that.
Okay.
But the people just talk on social media. Oh, after all, the U.S. has only 9 justices. Ghana, they have too many, 14, and they are trying to increase the number without any proper, uh, education or enlightenment about the jurisdiction of the Supreme Court.
Okay.
It's too large. It's nowhere near your Supreme Court there.
Yeah.
You know,
They don't take up
our
all cases.
systems. Yes,
Yeah.
yes, yes. It has original jurisdiction. It has supervisory jurisdiction. It has uh, this appellate jurisdiction. It has review. All kinds of things. There are about 5 or 6. It's a whole lot.
Yeah.
And the volume of litigation has surged more and more over the years. I think the last time, shortly before the elections, the Chief Justice was pushing for the appointment of more justices. And I was interviewed on that matter. And I said, yes, she was right. If only the process of appointment is genuine,
Yes.
yes. So if it's genuine, there is the need. And I was advocating about a minimum of 25 Supreme Court judges so that they have
Mhm.
at least 4 panels, because the Supreme Court sits on a panel, a minimum of 5 for, substantive cases. It's
Okay.
interlocutory matters, you can have 1 judge or then go into 3. Otherwise, the minimum is 5. And she brought out a caseload of about almost 800
Yeah.
pending cases
Cases. Yeah.
before the Supreme Court. And and then justice delayed is justice denied.
Yeah. Yeah.
If you have almost 800 cases, and the judges are 12 for, let's say, even 15, look at it, it means that each judge will be called upon to handle not less than 5 or more cases at a time. It will affect the quality of justice delivery. It's too heavy.
Yes.
And a record of appeal comes. A case, let's say it even commences from the High Court, a lot of evidence submission through the Court of Appeal and then Supreme Court. You have appeals from Houses of Chiefs, the National House, with leave of the Supreme Court of the National House. Supervisory jurisdiction is frequently invoked.
Okay.
Just, I mean, those normally are questions of law, but they are very loaded and contentious matters requiring a lot of reflection and deep research, so
Okay.
I said, even if it goes, if they have even up to 25, that's fine. But that will give a panel, 5 panels available at a given time. But
or should the jurisdiction be redefined to streamline the cases so that the Supreme Court doesn't have to take all cases?
Yes, I've been thinking of that. And it ought not to be so if the judiciary were soundly composed.
Okay.
Let's go back a bit. In the 60s, coming to the 70s and early 80s, I think the Court of Appeal, which was then the highest court, had only 5 justices. And there was no outcry about they being overburdened by anything. What happened was that the High Court was constituted by very sound judges.
Okay.
Aban, Francois, Redu, all sorts. They were very, 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 they came from the bar after several years of practice. And most of them tarried at the High Court for not less than 10 years before moving up to the Court of Appeal. So they were very much, experienced and, learned. And so appeals from their judgments were not
thrown out
often, because your chances of success were no good.
Okay.
You see, and that lessened the work of the Court of Appeal, and it didn't require, so that the 5 there were okay to handle things. But over the years,
quality
corruption crept in the bar, was diluted somewhere, indulging in sharp practices. The bench corruption crept in, particularly from, let's say, 2000 going, particularly as for the Supreme Court, it also got affected further down there.
Okay.
There was an element in it, but it wasn't of any serious dimension. But over the years, it wasn't.
Okay.
So, but the Supreme Court didn't even need to be the final appellate court. The Court of Appeal, if it is properly constituted, should be able to be the main appellate court, the last appellate court, because look at our judicial system, from magistracy to circuit to high before Court of Appeal. People are drawn from that trajectory, and sometimes from the bar. In the good old days, the bar, you had to be solid. So that if you were proposed to the bench, everybody was expecting that and will hail you. So people coming up were competent in the law and the principles. And so with that, I mean, when a high court judge, a sound high court judge gives judgment, as I said, in the 70s, the propensity to appeal was very low because the judgments were sound. They were very well informed judges, very learned,
Yeah.
And corruption was not yet any factor,
Okay.
But over the years, the guard was let down, and that's why people will be appealing from High Court to Court of Appeal to Supreme Court. I mean, are possible.
Yeah.
So, if they reconstitute the Court of Appeal now, I think they are about almost 50-something judges there. But that's because they have the provincial input. I call it provincial in the regions. Some judges go and sit there from time to time. But even there, the incidence is not so high that we need this kind of number. I remember when I was on the bench and I realized that the Court of Appeal had up to 21 or 25 judges. I used to make fun of them that you are a parliament, so you should elect your speaker. You should have a speaker. That's ballooned even beyond that. So the Supreme Court need not be overburdened if the judiciary is well structured in terms of quality, merit, experience, competence. I mean, you won't have so many cases going up. And the right of appeal ought to be really restored as it is as of right in almost all the stations. And so lawyers too, the bite of defeat is what will push them to appeal even where they don't believe the appeal
will succeed.
Yeah.
So
it's a question. Yeah.